been, what, about a month?
30 days.
30
yes.
days since you first walked into the office, you took the oath of office, and then walked in. What has it been like for the last 30 days as the top prosecutor in Baltimore City?
Drinking out of a fire hose, to say the least. It's been an eye-opening experience. There's some things that I didn't expect. Being the state's attorney, I can honestly say is very isolating in a lot of ways. You make decisions, and you have to kind of be patient to see how they unfold. I would say the best part has really been working in that office with some phenomenal lawyers. I've been able to understand how that office was able to stay afloat, and it really was the prosecutors that just loved the community and loved their work. And then, working with the team that I've assembled, they've been absolutely amazing. We sat down, we had our vision, and to really watch them, getting to work at 7, leave at 8 or 9 at night, and they're just working and working and working, and it's been very nice. You can begin to see the culture in that office changing. You can see prosecutors feeling positive, and it's a lot. They're helping one another. They're supporting one another, and that's the good part. The bad part is, it's like you bought a beautiful house and the roof has a leak and the floor is busted and the pipes are broken, and every time you look around, something else is going on. And there's still the learning process. If you bought this house, now you have the contractors you have to deal with who are doing their own thing. And so in the state's attorney's office, it's been a very humbling experience, but it's been an awesome experience nonetheless.
What are some things that were not working right away when you first walked in? I mean, we were there. We watched you walk into the office for the first time. It was pretty empty. Offices were dark. Papers were stacked up everywhere. Is that what you were expecting?
No, I was expecting look, even all the former presidents, and I'm not saying I was a president by any means, they left a note that at least gave some direction, something positive for the person that was succeeding them, because at the end of the day, they loved the country. And we didn't have anything. One of the things that's been so amazing to me is that our budget, State's Attorney's Office budget, was due December 16th. It was never filed. Not only was it not filed, there's a thing called the intranet. We couldn't find it on the intranet.
So it was never done?
It was never done. We had to have the communication with the mayor and over there in City Hall. They were the ones who've allowed us to walk us through this process to make sure things were done properly. And it's those types of things you're figuring out. Every day it's something different we're finding out. And what we realize is that it's going to take us longer to fix the infrastructure. But we cannot sacrifice the work of fixing the infrastructure for the safety of the citizens. And so we just have to work harder.
What did your predecessor leave you with?
A mess, to say the least. One of the things we found out is there were a number of cases that you have to make difficult decisions. And these difficult decisions technically were already made by divisions in that office or by experts, and they just decided not to announce these difficult decisions.
Was one of them the Donnell Rochester?
Without a doubt, one of them was Donnell Rochester. That was a case where we found out the Attorney General's office had issued a report back in August, and then the state's attorney's office, police investigation unit, they did their own investigation. And that investigation came out in October. And then you kind of wonder what happened. And so I had the opportunity to even see emails, because I went to the head of division and say, what took so long to announce this? And exactly was they left it for you because they knew it was a mess. And they knew the family was going to be mad at you. And then when you go through and you read what the reports are saying, and then you understand that, look, I understand the Attorney General's office issued their report, but some aspects of the report in terms of the actual defenses that the officers had, they didn't really consider those. Look, I'm a former criminal defense attorney, so the first thing I'm going to think about are whether the defenses. And then understanding that the Police Integrity Division under Ms. Mosby, they considered those defenses. And they took those into account. And they explained those defenses to her. as well as Miss Bledsoe, and they kept putting them off, putting them off. I saw a text message on December 28th that said, well, we should just dismiss it. And they said, we're going to leave it for the next administration.
So they knowingly sat on this information because they knew it was going to make the family mad.
It was going to make the family mad. It was going to make me, it was a problem for me. And, you know, that's exactly what they've done. And the other thing that's sad, and this is one thing that's to me, is you have a person that made their reputation prosecuting police. If they felt that they could prosecute the police one last time, do you not think that she would have at least prosecuted and filed charges to stick it to the police one last time? And that didn't happen. And so I had to have a difficult conversation. You know, I also had to have a difficult conversation yesterday with the family of a young man who was killed by a security officer, a Giant. And what actually was astonishing to me was this. A talk on the Zoom is about 7 or 8 family members, and I'm reading the notes. One particular family member had reached out to the state's attorney's office from February of last year through November almost 7 times. This incident happened in 2021. Ms. Mosby, the incumbent at the time period, the state's attorney, asked her division to reach out to a use of force expert and have them let us know if this force was the type of force that we can proceed on or is this actual self-defense. They had that information in February of last year. The use of force expert said that it's a viable defense. They never tell this poor family.
That's a year ago.
A year ago. They never tell. I had to have that conversation. They thanked me for having that conversation, but recognized part of the conversation was me apologizing for the trauma that the office inflicted on that family because they were re-victimized because they just weren't told. So part of being in this position, in the isolation, is you have to make tough calls. Now, I could have just sent a letter. I could have had my deputy to have the conversation, but the citizens elected me, so it was up to me to have that conversation. And it was a hard conversation because when you see a loved one on videotape lose their life, you want someone to be held accountable. But I also recognize, and the confusing part is people in the state of Maryland, I've always heard, there's no self-defense law in the state of Maryland. There is self-defense law in the state of Maryland. And the only thing I ask is that you give me the trust to allow me to analyze the case properly based on my almost 30 years of legal experience as a defense attorney. The first thing I'm going to look to see what the defense is. And then based on that, I'm going to make the decision that it's going to be fair following the law.
How many other problems do you think she left you?
There's so many we don't know. It seems to be a new one every day. There's a mess. And the only thing you can do is we can take our time to go through it. I'm sure a new one will pop up. You know, look, we have to deal with the issues that are the high-profile cases that were never ruled on. I'm going through there. I'm having groups of officials that presented the same presentations to the prior administration, presented to me so I can at least look at it from a different eye.
You made the decision about Keith Davis?
I did.
That was one of your first actions in office.
It was.
And I remember when you made it a point not to hold a press conference about it, but you answered questions from the media, and I could tell that it was a difficult conversation that you had with the Kevin Jones family. And why did you decide to drop those charges?
Well, to me, when you look at the law, it was clear that the state's attorney had abused her position. There was prosecutorial misconduct, I felt, and it wasn't just what I felt, but more importantly, it was what I read. So Judge Nugent had a hearing to see if there was prosecutorial, what they call vindictiveness, and that was based on a motion filed by Keith Davis Jr.'s attorneys. And based on the hearing from Judge Nugent, we read the transcripts, and Judge Nugent issued an order. And he said that there was prosecutorial vindictiveness in reference to the case that originated from the jail that came about after the murder of Kevin Jones. And so from our standpoint, that permeated through the entire handling of Keith Davis Jr. There was no way he was going to ever get a fair trial. Now, I recognize that I'd said, hey, we should dismiss this early on. And I felt that way. However, I recognize in this position, I needed to give it to someone who would look at it with a neutral eye. I gave it to Tom Donnelly, who was one of my deputies. But Tom Donnelly, within his own right, had a phenomenal career as an appellate lawyer. It was a person I trusted, and he would do the right thing. And one of the things he did is he looked at the American Bar Association rules for prosecutors. It's about 15 things they tell you not to do with a case. And he told me that it looked like 13 of them had been done by the prior administration. And so there was no way that young man was going to get a fair trial. And my job first is to ensure individuals have fair trials. And if it's not going to be a fair trial, then we have to look at it from a different light. I also asked the police commissioner, when I told the police commissioner that we were not proceeding, that if he could hopefully have his officers look at the case from a different perspective and point of view.
Do you believe the public will ever know what happened?
I hope so. You know, there are a lot of things that we look at in terms of cases that happened 5, 10, 15, 20 years ago. With the advance that we've had in science and technology, I have to believe that they will. And I do hope and pray that we find out for the Jones family.
Going back to just settling into the office and talking about the infrastructure, part of that infrastructure includes the staff and the support staff, the attorneys. How many attorneys did you end up walking in with who stayed on when you started?
I would say we've had a couple leave recently. I think we had about 139 were sworn in, and that included, I think, my 4 from my executive team. But we've hired 15 in this past month. A couple young prosecutors with very little experience, but probably about 12 of them have experience.
Okay.
We've hit the ground running. We have what's called an MIU, and that's the organization that does major investigations. We're able to hire an MIU attorney, not one, but 2 attorneys that came back that were in that unit underneath of Greg Bernstein, but came back to reestablish that unit. And that unit is so important because that's the unit that does the focus on organized crimes and gangs in our city. And they're the ones that will have the wiretaps. They'll work with our partners to ensure that we can focus on those types of violent gangs. The other thing that was amazing, we've gone and we had to reestablish all the relationships with all of our agencies that we work with. We would go into meetings with the DEA or HIDA or Strike Force, and they would literally almost applaud because they hadn't seen someone from that office in 8 years. There's no communication between that office on the previous administration and these organizations that were doing the work. They were totally isolated, doing whatever they wanted to on their own accord.
How could they be effective?
They weren't. And I think the crime numbers and statistics say that. And, you know, we met with Police Commissioner Harrison. Not just the commissioner myself, but our executive teams. And we went over there, he invited us, took my team over there, and we met with his team, and we talked about the things that we can all work together on. You know, it's like any relationship. You meet a person, you're getting to know the person, and you're finding out about that person. And as we begin to work with the police and understand what the police need, they will also understand the things that we need. And having that line of communication, we can put better cases together to hold people accountable. And so we're rebuilding all those relationships.
Do you believe that the way the office was run under your predecessor put public safety and the people of Baltimore at risk?
Oh, without a doubt. Because what it did is that not one person, not one organization can really focus on public safety by themselves. They must work collaboratively with all of the other organizations, whether it's the mayor's office and say Mikenzie that may be doing something with the low-level offenders and giving the diversion programs, but you're still now working with the police to hold these individuals accountable. Whether it's the governor's office and you're getting funding from the governor's office to have these programs, to have the wiretaps, we're working with the Attorney General's office to focus on these violent gangs, and also the U.S. Attorney's office to go after these gun offenders. In the state's attorney's office, we have a thing called a SALSA position. That's a state attorney that is a U.S. attorney. Okay. And so basically, they're what we call cross-designated. But they didn't really have anybody from that office doing that job. And that's important. Now, they had someone they wanted to do the job, but that person was so inundated with cases on the state side that they really couldn't focus on the cases on the federal side. And so now we're now in the position to say, how can we get a SALSA over here to do this work? So this way, we can work more collaboratively with the U.S. Attorney's Office. So if there's a person who we see as a violent repeat offender and they have a gun, and we have a case that we feel very comfortable with, we can now take that case from the state side to the federal side. The federal side, they changed the law about a year ago, and now instead of 10 years, they're looking at 15. And it's not 25 or 50%, then you get paroled. They're going to do at least 80 to 90% of that 15 years. And so that puts us in a different position in terms of holding people accountable.
Well, and during your inauguration week, you had all these various events, including a town hall with law enforcement partners. And that was for the first time we had seen all of these leaders together on one stage, including the U.S. Attorney Eric Barron. I know that there's been conversations about working more collaboratively, especially when it comes to the gun offenses and repeat offenders. How do you see, or is there anything that the General Assembly could do when it comes to legislation targeting repeat offenders that could help you protect people in the city?
Well, a couple of things. First, I want to talk about Eric Barron. The relationship that we have is, once again, my deputy worked with Eric Barron in the state's attorney's office together. Eric Barron and I were on what's called the CJ panel, where we represented individuals as defense attorneys, where the federal courts selected us to do that. Mr. Barron walked over to our office the other day and walked through the halls just to talk to some of the prosecutors in my office so he could let them know that there will be a true partnership. He went to our gun division to say, keep working the way you need to. We have your back. That's huge, because when you see leadership from another organization come to say, I have your back, we're on the same team, we're working together, what it did for the morale of the people in my office was huge.
What was the morale before?
It was terrible. I would say I gave many speeches that first week, but the most important speech was the speech I had to give to the people in that office. I was able to go to courtroom 400 in the Clarence Mitchell building. They had 2 groups of 80 apiece. I needed to sell them on my vision so they would stay. 70 to 80% of the people in that office already had resumes that were out looking for jobs. I did everything I could to sell them on that vision. I received more texts, not only from the prosecutors, but from the support staff that said, I feel that we can make this change and I want to be a part of it.
Why was the morale so bad?
I think what you found out was that in the front office, they made decisions in a silo and didn't necessarily always think about how it affected other people. And I'm not just talking about the former state's attorney. I think there was a lot of miscommunication. There appears to be not a lot of communication. One of the things we asked some of the people, because now we're trying to interview everybody, to say, where do you want to be in 5 years? What do you want your career to look like? What types of cases would you have? My deputy was talking to one young lady yesterday, and she began to cry because she said no one had ever asked her that, because she felt that she wasn't that important, that they cared about what she wanted for her career. I just think that office, you had a lot of attorneys that did not feel that their leadership had their back. And to me, that's something that it's important that they know. That's why that speech was the most important. I could be the state's attorney, but I can't try as many cases as everybody else is trying them.
You are trying some.
I will be trying one case right now, murder case, with a prosecutor.
Yeah. Who,
to me, is one of the best prosecutors I ever had. Like I tell people, every time I saw her name as a defense attorney, I was mad because I knew it was a battle unlike any other. But that was important because I'm a trial lawyer at heart.
Yeah.
And I want the prosecutors in the office to see, okay, I'm standing behind you, and some days I'm in front of you, but really, I'm right beside you. And the same trenches you're fighting in, I fought in before, and I'm ready to go back to war and I'm right next to you. Because going to trial every single day, fighting for the citizens, that's what I signed up for, and that's what they asked me to do. And that's why it was important for me to take that case.
Going back to the legislature.
Yes.
What can the lawmakers in Annapolis do to make it easier for you to go after the repeat violent offenders?
Well, in reference to the repeat violent offenders, I feel pretty good right now understanding the law.
Okay.
But the main issue is there's a law in the books that if you're a prior felon and you're caught with a handgun, we can ask for 5 without the possibility of parole up to 15. And my office now is doing that. So the laws were on the books. The state's attorney's office, for whatever reason, wasn't calling those on a consistent basis. You know, the other night I heard a jail call of a young man that pled guilty, and he was talking about the reason he pled guilty was because he heard Ivan Bates was going after gun offenders. Matter of fact, he said he was watching Fox while he was over in the detention center and said that. And that's true. And he also knew if he lost, my prosecutor was going to ask for 15 years. And that first 5 without the possibility of parole, so you're going to go away for at least 7 to 8 years. But the legislation I can talk about is the legislation that now is in the House, where when you look at a handgun, an illegal handgun, this legislation isn't about mandatory minimums, but what it says is if you have an illegal handgun and you possess it in your car or on your person out in public, that now I want to change the penalty from 3 years to 5 years.
Why was that your first move? First legislative move?
Well, look, everybody knows I was a criminal defense attorney. A criminal defense attorney, my clients would tell me 3 years, oh, I can do that on my head. And this is why they would say that. In 2016, you had the Justice Reinvestment Act. And what that said was that if you're convicted of a misdemeanor, which where, carry, and transport a handgun is, that you only serve 25% of your time. So my clients, as a defense attorney, knew that's 8 months. That's time served. So they were never, ever intimidated, afraid, or deterred from carrying a handgun. But the magic number that everybody seemed to be afraid of was 5. Because 5 years means you're going to the Division of Correction. Now, you're not going to go for a long time, but you're going to go long enough that you're going to understand what it's like to be in the Division of Correction. You're going to understand here, local time, your mother, your cousin, all your friends, everybody sees you every other weekend, every weekend. You know everybody up there, people from your neighborhood, people you grew up with. Division of Correction, people can't just drive out to Jessup or Cumberland like they want to, Hagerstown. You know, and so that is a mentality that I understood was one of the reasons I felt that we need to focus on this bill.
But will it help if judges aren't giving those sentences, or aren't delivering or handing down the 5-year sentences for these offenders?
Well, that's what we have to focus on next. We have to win those cases, and then we ask the judges for those sentences. And one of the things I do know is there are bills in Annapolis that talk about justices being and judges being held accountable, but on their sentencing. And so I also know this. The judges live in these neighborhoods. They live in the communities. And they're going to have people accountable. I can't control what the judges do. But what I can control with this law is my prosecutors will be prepared, and we win the cases, we're going to ask. Eventually, that we'll have to deal with the judge in another way, in another form. But for us, if the judge says, I'm only going to give you 6 months suspended all but time served. Say I'm going to give you 5 years suspended all but time served, and the time served is 6 months. That person has 4.5 years hanging over their head. And so what that also means to me is this. We have to now be creative. Let's talk about if this person's on probation in the county. Then maybe we take some of these violation probation cases in the county and we reach out to the county or other jurisdictions to say, this young person has another gun case and they're on probation. A judge in the city may not give them the jail time on this gun case, but what's your judge in the county going to do on the violation of probation? That's how we think globally in a different way where we partnership with everybody.
Was that communication and partnership in place before?
No, it never was. You know, I'm a member of the Maryland State's Attorney Association. And, you know, one of the things you realize is they welcome me back with open arms because that relationship just hadn't been there.
And they're supporting this plan, correct? The State's Attorney Association?
This. Yes, they do. And they support it because also not only will we feel a deter crime, but we also feel it's fair because if you're between 18 and 20, you're looking at 5 years and $10,000 fine. Why is that for an 18 to 20-year-old, but we're not doing that for someone older? And to me, when I think about, I want to deter people from carrying guns because we know too many people are carrying guns. Let's talk about that mass shooting last Saturday. One person drives his car, shoots the man, a young person, and shoots a homeless person, kills that individual. Then there's a mother with a 2-month-old infant and a 3-year-old toddler. She does what any mother would do, grabs her children, throws them into the car, and speeds off. And then from the video we've seen on TV, there are a number of individuals in a little restaurant, bodega, whatever, carry out, whatever you want to carry it. They all pull out their handguns. And then they just run outside and just start shooting like it's the Wild West. When I knocked on those 15,000 doors, I heard that story time and time again. They're tired. They said, Bass, I'm sick and tired of being sick and tired. And so for me, I want it to be crystal clear. I need this legislation to hopefully is the deterrent. So they will not carry these handguns on their own person. They weren't carrying these guns like this before Freddie Gray. Now, I recognize individuals still will have guns, and those individuals will continue to go after. But those kids that feel that they just need to carry guns, because now these individuals, if and when we catch them, now instead of looking at 5 years or 18 months or 13 months in jail, now you're looking at a murder charge. And I'm sure an attorney's going to say, oh, they're a juvenile, they're this, they're that. I get that. But what I have to look at that no one considers is this. I have a 2-month-old and a 3-year-old toddler. They will never have their mother tell them they love them. They will never have a mother ever go to their first day of school. They will never have a birthday party where their mother is. And that mother and those children, they look like me. So I recognize my job is to be the voice of those victims that for so long we only thought about the defendant. And that was my job. I did it. I get it. That's a defense attorney's job. But my job is to think about that 2-month-old and that 3-year-old toddler. Because the actions of young people carrying guns, and they were young people in that video, that's what we saw, unfortunately, in murder.
Well, I'm glad you brought up juvenile crime, because that is the conversation happening across the state right now, especially when we look at various legislation that's passed and is now law. Do you agree that there should be a blanket rule that prevents kids under 13 from being charged with a crime regardless of what it was?
You know, that's difficult in the sense that I think that blanket rule makes it very, very difficult when you look at the crimes and the charges. Out of all of those, I do struggle with that because I see the pros and I see the cons. But I do believe this, if you're not going to charge them, what is DJS doing to hold that young youthful offender accountable? Maybe it's not a charge. Maybe then we find a way to give the citation or whatever to the parent to hold the parent accountable. My office just charged yesterday the grandmother of the 9-year-old that was accused of shooting and killing the 15-year-old. So now what I'm saying is, okay, if you're 13 or your children are going to have these handguns, and they're your handguns, they're legally, you purchased them legally and have them, if they're not stored properly, you can be charged. So if we're not going to charge someone that young, we still have to hold them accountable. And what does that accountability look like?
What does that look like? Because that is the big question. And that's the question we've been asking lawmakers right now about, okay, if this is the law in the books, what can you do to ensure that kids are held accountable and that they change the path that they're on?
Well, I think maybe one of the things we have to maybe look at the parent or guardian accountability and looking at that. Because yes, they are children. Their brains are not developed at 9, 10, 11. I understand at 12. I get that. But they have to be held accountable in some sort of way. And if we're not going to hold them accountable, we got to then look at the parents.
We've done a lot of informal surveys, polling from our viewers, and depending on the question, it ranges between 90, 95, 98% of everybody from our viewers say that they want to see these young people held accountable, but they also want to see, they say that they want to know when these crimes are happening. They want to know about this information. Should the names and the information about the cases involving these juveniles be shielded from the public if it perhaps involves public safety as a whole?
Well, I think when you look at some of the more violent felonies, I think they definitely need to have the opportunity, the citizens need to have the opportunity to understand what happened with that case. The low-level offenses, no. But I think the violent crimes that we see that have the opportunity to be tried in adult court, I do feel, and that's important. And that's part of holding people accountable. How we go about doing that. Now remember, there's a victim, but not just a victim, there's a community that's been traumatized by these actions of some of these young people. And so they have to be held accountable as well, because the whole neighborhood will understand what happened, will know what happened. And so you're just saying that's not the way we're going to do it. I think there's a way we can figure out where we allow the community and understand what's happened with these young people and these charges, and we do it in a way that's also safe and protecting the young individual. Now, I do understand that now once they're in juvenile court, now, of course, since in juvenile court, it'll be shielded. But I think there also must be a way in which the community still understands some of what's going on in juvenile court. It's a mystery what happens in juvenile court. As I say, it's a deep hole. It goes, and we don't find out what happened.
Yeah, and that's frustrating for a lot of people in the public when they know something happened. They were fearful during an incident, and then they never hear about it again, and there's no way for them to get any information.
Yes.
You brought up DJS, and I want to talk more about the Department of Juvenile Services. The nominee, the confirmation hearings for the possible secretary for DJS, the hearings start Monday, so that confirmation process is starting. He's potentially controversial given his previous statements about the fact that he doesn't know if kids should be charged given their age. People reach 21, they shouldn't have a criminal record for crimes committed before that. Do you agree with that?
I'm worried about the victims, and I understand you're worried about the criminal record, but that young person made a decision. That young person, especially if it's a gun crime, especially if it's a violent crime, a carjacking, robbery, or murder, they still have to be held accountable. And I understand we don't want them to have a record. I get all of that. I really do. But I do think that there's a way in which we can balance what we need to do in terms of holding a young person accountable and the record aspect. But at the end of the day, if a young person commits the crime, they must be held accountable. And if it happens when they're over 21, then they have to continue to have that record. Now, 12, 15 years later, no new offense have ever happened, then there's a different way. For instance, within the law, you have what's called a writ of error cor nobis, that a person who's of that age can file a motion, and maybe we change the law in terms of writ of error cor nobis is to say, if you had a juvenile conviction and it's more than 15 years of age, then now the court can listen to find out if that conviction you had was a juvenile, can maybe be looked at and be not necessarily expunged, but maybe shielded from getting a job, getting those types of things. But to just outright say we're not going to do that, no. I'm really big on second chances, earning second chances. But there are vehicles within the law to do that. And once again, the writ of error cor nobis, I used it many times as a defense attorney, so I know it's out there, I know it can work.
Do you think somebody who has those views about the possibility of not charging kids or keeping crimes off records, is that the right person to operate and run a department dealing with juveniles who have been involved in a criminal activity?
I don't know enough about his background, but what I can say is this. When you look at what happened with the DJS last year in 2022, those types of views definitely would have some concerns, because one of the things, it used to be that if there was certain crimes and DJS decided not to charge them, because remember, the crimes technically start with DJS, then DJS refers them to the state's attorney's office to prosecute. However, it used to be any time the state's attorney would have to sign off not to prosecute it. Now, under the law, it's changed. DJS can say we're not prosecuting because we don't find it violent. So, what is violent, what is not violent? So,
there isn't a clear definition of what that means?
I believe I know the definition, but I want to know what DJS is determining as violent or nonviolent. That's something different? That I want.
Okay.
Well, I don't know if it is.
Okay,
I see. What I'm saying is that I have never really seen in writing, these are the violent crimes, these are nonviolent crimes. But let's sit down and say, there's robbery. Let's say they're saying robbery is not violent unless a weapon's used. I don't know. But what I'm saying, when you look at the law and the nuances of the law, there are a number of ways in which you can make it work to say that this wasn't a violent offense. In a number of ways, as the state, I can say it is a violent offense. I want to know those things because with the law changing, that's something I feel the state's attorney's office really need to understand and know, because I would like to have that nominee define what he views as violent, what he views as nonviolent, because I think that would allow me to have a better understanding in terms of the mindset of way he's looking at the law. I recognize some of these writings were in New York, some of them also down in Washington, D.C. I've heard some very positive things, and I've also heard some other things that are a little concerning. But I'm also a big believer in that The governor went did his due process, and this is who the governor wants. And I'm a big supporter of the governor. But what I am also going to do, I'm cautiously optimistic because I want to really understand truly the makeup in terms of what this gentleman is saying about the law.
We'll see what the hearings bring starting Monday. Looking at just you talked briefly about the communication and looking at the city itself, I understand that you went to the last consent decree hearing, and from the buzz that we heard, that was a surprise to some. Why was it important for you to go there?
You know, I'm going to tell you what's crazy to me. I don't really think that this is my job. So I don't understand the buzz because my job is to understand, as a state's attorney, to consent decree so I can understand what we need to do to support the police department and what we need to do to make better cases so that we can hold people accountable. That's why it's important. But I honestly feel that's my job. I mean, look, at the end of the day, I was in a private world. I understand private world. But now I work for the taxpayers. And I understand the same person's driving a bus, the same person's working at McDonald's, and they're taking money from their check. They're paying my salary. And they demand those actions. So for me, I understand how hard it is to earn money. My father instilled that in me as a young kid. So the only thing I'm doing is doing what I feel is my job. Because when I ran, I made promises to the people. I told the people this is what I was going to do. And so the only thing I have is my name. And my name means I'm going to do the job. I mean, you may not always agree with my actions. You may not always agree with my job. But you need to just understand I'm going to do everything I can to make sure I do the best job possible. And that's why it was important for me to go to consent decree hearings.
Wait, you talk about being a public official, taxpayers pay your salary, and with that brings a level of transparency for the public. The public knows the names and salaries for most elected leaders, government workers, police officers, your state's attorneys. But there's other your assistant state's attorneys, excuse me. But there's other programs that the city operates that level of transparency isn't there, even though they're dealing with public safety and community violence, one of which is Safe Streets. The public knows officers' names, every other name in the city government, but the public doesn't know the names of these workers who are employed, quasi-employed by the city. Does that raise any concerns?
Well, I mean, I don't know. I mean, you definitely would know, but I thought the city published everybody's salaries on the website.
They do, but the Safe Streets workers aren't employed by the city because they're technically employed by the community-based organizations who get their funding from the city. So it's a pass-through, and it's a way for the city government to shield this information from the public, even though they're being paid by tax dollars.
Well, look, I'm a big believer if the taxpayers are paying it in its salaries, and the taxpayers have a right to know that information. I mean, I paid a lot in taxes last year as a private citizen, and you want to have that information. I think that's fair, but I try to also stay in my lane, as I say I only can control what I can control in the state's attorney's office. But as a taxpayers, yeah, they want to know that information.
Project Baltimore, our investigative team looking at the schools, they've uncovered a lot of things about city schools that have raised a lot of questions. Ghost students, ghost classes, potential police overtime questions. A lot of this has been investigated by the state at the Inspector General for Education level, but would you, given what we've learned, would you dedicate any investigative resources to look into what's been uncovered?
Well, I think that's very important, but what I can say, talk about problems, let's talk about the Economic Crimes Division. Economic Crimes Division had about 400 and some open investigations. That's right, 400 and some as old as 4 years old. Exactly.
What are they doing?
I don't know what they were doing, but they weren't focused on that. And so we would love to be able to move in that direction, but we need to have more prosecutors with experience. Mm-hmm. But right now, I have a new head of the Economic Crimes Division, Sherry Green, been in the division before, phenomenal prosecutor, been in that office for a while, needs to be able to look at those cases. The Inspector General has referred a number of cases to our office that they just never really actually looked at.
Really?
So they're there, but they just didn't do anything with them. So we have to catch up on the back order before we can focus on what else is in front of us.
How long is that back order list?
There's a 416 case. I talked to that prosecutor today, and they're working 10 to 12-hour days doing their best to catch up. But when you're dealing with complicated financial cases, you need to look through the financial records. It's going to be thousands of pages. And
it takes time.
It takes time. And so realistically, I would love to be able to focus on that, but my focus is I can't focus on that until I focus on what's already here.
How many other open cases are there? I mean, not just in the economic crimes, but...
You know, when I talk about what's going on in the state's attorney's office and I talk about the prosecutors, let's talk about the homicide prosecutors. Let's talk about Rita Wichita-Fido.
Let's do it.
She's currently carrying 25 to 26 open homicides. And what does that really mean to the average person? A prosecutor should only carry between 10 and 12. Why? Because you have to do investigations, you have to charge, you have to prepare. If you're carrying 10 to 12 murders, you're going to go to trial once a month. 25 means you go to trial twice a month, which means you can be in trial anywhere from a week to 2 weeks, which means oftentimes you're not getting any break whatsoever. So you're in trial after trial after trial after trial. So you're going to burn out. You're not going to be prepared as you need to be. And guess what? That violent repeat offender will now go free. And they're going to go free because you could not be prepared because you just had too many cases.
Is that where we saw a lot of the plea deals coming from?
I believe it was because they were just trying to do triage, holding someone accountable. And we're still doing triage in many ways. When I sat down on January 3rd and I said, we're going to go ahead and give the police the tools they need to go ahead and enforce low-level offenses. Get there, go to the district court, it's crickets. Want to know why? When the previous state's attorney announced that there would not be any more prosecution of low-level offenses, they didn't bother to hire district court prosecutors because there was nothing for them to do. So we had to hurry up and get district court prosecutors. We have to hurry up and train them. So we can't all of a sudden have the police start enforcing low-level offenses because the system will break, because we don't have the prosecutors who know what to do the cases. So we've gone to the judges to say, judges, will you do me a favor? Judge in charge district court, could you please, we looked at the dockets, meaning the cases, and we see Friday there aren't that many dockets in the afternoon. Could we consolidate those Friday afternoon dockets maybe earlier in the day so we could have every other Friday as a training day? So the court said yes. And the public defender's office, other organizations can have every other Friday in the afternoon to do whatever they want because they're not going to be dockets. We, state's attorney's office, we're going to be going to training. We're redoing our training staff. We had a gun training last week on how prosecutors can deal with illegal handguns, how to hold the gun, how to introduce the gun into evidence, what ballistics looks like. Myself and my deputy, Mr. Donnelly, we went over to the Baltimore City Police Department to do a training. I looked at the DNA lab. I understood what was going on with the drugs, how they're being analyzed. This is the same training I did 20 plus years ago. I wanted to see for myself because I have to understand. So what I'm saying to the citizens is, we're coming, we're getting there, but it's just going to take us a little time to get up to speed. My hope and goal is May, June at the very latest, the police will all of a sudden be able to enforce those level crimes, and we'll be able to have the systems put in place to hold those individuals accountable. But realistically, I didn't have the bodies, I didn't have the prosecutors, I didn't have the experience. When I talk about people coming back, one's a young man named Jim Zoyce, who's a friend of mine. We were prosecutors in the office 20 plus years ago. He was a very successful insurance defense attorney, was sitting at home, said, Ivan, I just want to come work. And what are we going to do, Jim? I just want to do district court cases because I know they need help. Those are the types of prosecutors that are coming, what I say, off the bench, off the sidelines, that are bringing 20 years of experience in courtrooms to say, you know what, I'm here to help you 2, 3, 4 years so we can rebuild our office, so we can hire the young talent, so we can train the young talent. But we need middle-level prosecutors in that office to be in the courtrooms with these young people to say, hey, this is how you handle this case and this is how you don't. And that's how we can eventually make the system work positively for the citizens.
Do you think 2023 will be safer in Baltimore than 2022?
I pray it will. And we're working hard to make that happen. I don't want to say, oh, yes, without a doubt. Only thing I can do is my part. And my part is working collaboratively with the police. is to make sure my prosecutors are better trained. But these cases will be finishing up in 2023. These aren't the newer cases. A lot of these are cases that already had problems, that already had issues that we have to deal with. Now, 2024, those will be cases having had a better relationship with the police department, having better trained prosecutors. This is a process. You know, look, we like sports. I know you're a big football fan. If you think about last year with Michigan State, the team they started with at the beginning, they began to gradually get better with the young talent in the end. And so to me, that's how I look at it. I love sports. The Orioles took some time with their minor league. They had to draft them, they had to train them, they had to put in the training program. And the Citizens, we were patient. I'm asking the residents to just give me some of that grace. Give that office the patience, continue to pray for us, and recognize that we're doing the best we can. We see the ship was about to sink. We're trying to steer it back. We're patching the holes. And we do recognize that we have young people on the way where they're going to be better trained, and they want to be prosecutors to protect the residents. So my goal is, yes, I'm cautiously optimistic it will be, but we have to do our part, and we're working to do that.
State's Attorney Ivan Bates, thank you.
Thank you.